Um, Folks, we started going back in the syllabus like very early on, topics and categories. And I told you this is the syllabus that's the really kind of like compounded tested one. It's like the different categories, if you will, and how many questions they could be. Like if it's in this section, you could get questions on it. And truth to be told, your North Carolina test, I told you, I wrote most of it because the way that the North Carolina test has changed over the year is pretty substantial. Because it used to be a 40 question exam at the state licensing level. And so we kind of matched it. And folks, as you might imagine, they moved it to a 60 question exam. And so that's a 50% increase. So I literally had to just come into the syllabus, find North Carolina categories, see what's in here, and just start writing questions based on the things that they throw in. So this is what I looked at whenever I wrote most of your North Carolina exam that you're going to be taking this weekend and the retake next weekend, at least the North Carolina specific category. So to the best of my recollection, I think we left off right around here, page 50 something, because we had just kind of like reviewed agency a little bit. And I don't think we did as detailed of a review on agency because we really just had some detailed discussions on, agency and things of that nature before we got into the actual review in the North Carolina License on Commission Rules section. I will tell you that if you look at this category that we're starting off in today, real estate practice, 14 items. And so there's going to be a decent amount of questions from a national point of view and even a state point of view for probably some of these things. And a lot of this arguably could be some common sense things like, well, what is a broker going to do? And then, of course, understanding like who a broker represents. I've been telling you from day one, if they're a client versus a customer, there's vastly different things we're going to do for them. And so you're going to get questions like such and such working with a buyer customer. And then it's going to say, well, they find out confidential information, even without me finishing any more details of that question. If I say that an agent's working with a buyer customer and they find out confidential information, what can you tell me that they're probably going to have to do with that information?
Report it back to the seller.
There you go. Because if this buyer's a customer, the only other person they could have, unless we were doing transactional brokerage, which is a thing on national land, but that's not where the questions are mostly going to go. It's going to go back to the seller. And so you're going to have a lot of these questions on, do we have obligations to disclose material facts regardless of who we represent? Yes. So let's just talk about some of these different things. Practice within scope of experience. Obviously, this would be, no residential if you're doing residential transactions, no commercial if you're doing commercial transactions. Of course, we've talked about this. Avoid the unauthorized practice of law. We as real estate brokers deal a lot with attorneys. We deal a lot with legal jargon. We deal a lot with contracts. And so we can start to feel dangerous at a certain point where like, I could write a contract. Folks, I feel dangerous like that all the time, right? When I graduated high school, there was two options. I was going to be an attorney or I was going to go to culinary school and be a chef. And then I looked at the school options and how much schooling it was. And I was like, well, we're going to go cook for a living. That's what we're going to do. And now I sell real estate and teach real estate. So, but I always wanted to be an attorney because I liked law and I liked arguing with people. It just seemed to be a good thing to do. And so here I am thinking I could probably write a document that would be legally sufficient. I know how to use all those words. I can't do it though, right? I'm not an attorney. So be careful. Because I told you when we talked about some basic contract law section stuff, you cannot write legal documents on, I could always start a food truck like that. There you go. Or like, what's his name? Bradley Cooper apparently opened a food truck now. Did you see that? Hotshot movie star. He has a food truck apparently. So doing it for others is the law part. And so I gave you a couple cautionary tales. Could we as real estate brokers make modifications to an agency contract? Yeah, because we're a party to that. So it's not for others. Could we as brokers make modifications to a sales contract? No, because that's for our clients, not us. So to do so would be the unauthorized practice of law. Now, could our clients draft up their own contract and we use it? Yes, that's going to be a test question when you take it this weekend. If a client writes up their own contract and says, I want to use this, and you use it, have you violated your duties? No, that's their prerogative. If they want to use their own contract, they can. If they want to draft up their own addenda, they can. The other thing that I told you to be very careful with, and I doubt that my questions and or the state licensing exam questions are going to go this far, but technically speaking, if they told us the exact language to write in for a contingency, I told you that would be considered being a scribe, and we'd have to notate that we did it, and they would initial that accepting that they came up with it. And under those circumstances, that would be okay. But if there's ever anything like, yeah, even a napkin, that's right. If there's ever anything that said like, you're going to add in a contingency, say no. That's the unauthorized practice of law. But if it's with very explicit instructions from them, sure, maybe that's okay. Just be careful with those types of questions. Other things we talked about, you don't want to steal business from other brokers. To do so would be a violation of Article 16 of the Realtor Code of Ethics. Remember, not all brokers are realtors, but this does get thrown around a little bit in this, right? In the Association of Realtors stuff. You don't have to be a realtor. But then also it's considered tortious interference of a contract, right? You have this contract, and to interfere with other people's contracts is a potential violation of civil law. You could be sued for that. That one. There we go. Got some more people here. Remember to, I kind of gave you this warning. When we're dealing with agency contracts, understand there are so many different types. There is, of course, an oral buyer agency agreement, which is express, meaning clearly stated, including whether or not we can practice dual agency, when it has to be reduced to writing, how we expect to get compensated. So you got this oral buyer agency agreement, non-exclusive, open-ended. You've got a written exclusive buyer agency agreement. You've got a written non-exclusive buyer agency agreement. And then on the listing side, we had three that we talked about, right? An open, an exclusive, and an exclusive right to sell. And so be careful, I warned you, because you may have questions on the test that say something like, such and such is assisting somebody by way of an exclusive right to sell listing agreement. And the question may be about that, or it may not be about that. And so you've got to be aware that sometimes there's extra information that you don't need. So I'm not saying ignore it, but I'm saying be very careful on what you're answering. Because if the question is, about material facts, does it even matter? What kind of agency agreement? No. And so remember the distinction. Open, multiple firms hired. Only the one who brings the buyer is entitled to compensation, but the seller has the right to sell it themselves and pay nobody nothing. Exclusive agency, they've only hired one firm to market their property, and they're going to do it normally through the MLS. If any of their marketing efforts, even another broker, right, through their marketing efforts brings a buyer, the brokers get paid in exclusive agency. But yet again, an exclusive agency, the seller retains the right to sell it themselves and pay nobody nothing. And then an exclusive right to sell, we get paid no matter what, no matter where the buyer comes from. No ifs, ands, buts, or coconuts, as I like to say. Lisa says, are all open agency agreements unilateral? Arguably, most often they are tested that way. Why? Because it's, if you bring me a buyer, I will pay you. And so there's this whole aspect of, you may or may not bring them a buyer. So it really is more often tested as open agency contracts are unilateral contracts. Just be careful with it because, that's not a set in stone kind of thing. But what you got, Karan?
Unilateral means that only one party signs. Bilateral means that both parties sign.
Well,
or agree.
No, both parties sign. It's just that, we agree that this thing exists, but we don't necessarily agree that it is what it is. Meaning, if you think about unilateral, think our offer to purchase standard form 2T in North Carolina is really unilateral. Buyer signs it, seller signs it, but what makes it unilateral is the due diligence period gives the buyer the right to back out for any reason or no reason. So they haven't guaranteed that they're going to buy the house. Even though they've signed it, we've all know that they've got this, it's basically the equivalent of an option period to back out. And so same thing with an option to purchase, both parties would sign it. It's just one really has purchased the right to not move forward if they don't want to. And then same thing with an open listing agreement. Both parties are going to sign it, But it may be like, I mean, it's only if I bring a buyer are you going to pay me, and I may not be the one bringing you a buyer. So that's why it's more often a unilateral. It's not necessarily the signatures that's the indicative piece of that. It's how substantial is the promise or not. Have I said I'm absolutely going to do it, or have I said I might do it? Yeah. Yeah. So, of course, we talked about limited service listing contracts. Remember, we don't call them discount brokers because that's an issue. Nathan says, unilateral, I'll give you $100 to mow my lawn. Yeah, if you mow my lawn, right? If you mow my lawn, which means if you mow it, I have to pay you. But did you promise to mow it? No. And then, of course, I promised to mow your lawn. You promised to pay me. That's now an obligation. That's a bilateral. But it's that if piece. If you bring me a buyer, I will pay you. If you move forward, right? If. Protection agreements, remember, be very careful about those. I don't necessarily know exactly how testable they are on the state licensing exam. I think I may have a question or two about it. But don't confuse that with the protection period. Remember, the protection agreement is the document that you use to protect yourself in a for sale by owner situation. And so you give it to the for sale by owner, and it reminds them, I don't work for you, I work for the buyer. And you are promising to pay me. So it's kind of protection in two ways. And remember too, if you are a buyer's agent talking to a seller or a seller's agent, you have to disclose your agency status when?
Immediately.
Initial contact. Robert, everybody's curious as to who Bo is in the group chat. Is that you?
Yep, that's a nickname. I tried to change it like 3 times, but didn't work.
Okay. Yeah. Well, I think Ayana called it. Yeah. She was guessing that it was you. And I'm like, I don't know who Bo is, but Bo asked if I could cover a bunch of very specific things today. And I was like, well, I'm sure if I knew who Bo was.
Well, I made a list of questions, but my dumbass literally put them down by question number and not like writing them all out. And then my computer crashed, and now I can't pull the test back up. And obviously, they were one-time practice tests, so those questions are gone. As is my list.
Well, the good news is, if they're super consequential to you, Robert, I can pull up your test.
Okay, and most of them, it was actually a little bit of math. But yeah, were you planning on getting to any of the pity and the lowest monthly income, calculating that stuff?
Yeah, we can. Let's do that in just a moment. Get through a little more of the syllabus, and then I'll go to those questions. But yeah, I can pull up that test and take a look at it.
Sweet.
Yep. Also, be aware, folks, that there are not going to be any oddly specific things in an agency contract. So, for example, one of the things they love to test you on or trick you on is, is square footage going to be in a listing agreement? No. We don't measure the house before we sign a listing agreement. We measure it as part of, our job to sell it. So, things like meets and bounds legal descriptions, not going to be in it. Things like square footage of the house, not going to be in it. Specific features of the house, also not going to be in it. What we do talk about is personal property and real property, right? That's going to be a big part of the listing agreement discussion. What stays, what goes, whether or not we can practice dual agency, what are our obligations to you, what are your obligations to us? And I cannot stress this enough. Listen very carefully, because I told you, you have all heard me just harp on this so many times throughout class, but the amount of students who get it wrong. When I have document or like a question, it says, the document that outlines the relationship between the buyer and the agent, the respective duties to both, and what type of property a buyer is seeking to buy. I cannot tell you how often students pick listing agreement. You've got to understand the parties to an agreement. Who are the parties to a listing agreement? Seller and the firm. Buyer agency agreement, buyer and the firm. If we're talking about the buyer and the agent, my God, it's the buyer agency agreement. You think I'm joking. Like that question is missed like 75% of the time. And I think people's brains just go numb in the test. And I told you too that this is where like sometimes students will be like super offended at how bad their score is. And I'll have like, let me show you your test. And then I show it to them. They're like, oh, yeah, you did that. That was you. You made those choices, not me. So then they're just like, having a little pity party on them. No, I'm like, listen, it happens. What you got, Nathan?
That was just pertaining to one of the practice questions that we had, the square footage. It said that the agent can, if the agent does put that square footage in the listing, it just needs to be accurate.
It's absolutely right. And you're going to have questions like that, but it's not going to be, it's in the listing marketing. It's not in the listing agreement. Yeah. Not in the listing agreement. Yeah. So just be very careful that there's not going to be crazy specific things in the listing agreement, right? We're going to name the property. We're going to name, these are all the main things, right? We're going to talk about earnest money. We're going to talk about the names of the parties. We're going to have, and remember all in North Carolina. Now this is more of a national section. But remember in North Carolina, there are 4 things required to be in every written agency contract. Who remembers what they are? 4 things required by law to be in every written agency agreement in North Kakalaki.
Fair housing, anti-discrimination.
Yeah, the non-discrimination provision. Yep. That's exactly right.
Meeting of minds of both parties.
Not that one. I mean, that's required under basic contract law for a valid contract, that mutual agreement. But we're talking about the specific things. They go, at least the termination date. These are specific things required under the agency agreement and disclosure rule in North Carolina. So we got the non-discrimination provision, the termination date. Compensation is not a legal requirement. So don't get caught up on the test on that. It's going to be in there, but that's not a legal requirement. There you go, Chris. The individual broker's license number. And the last one is signatures of all the parties. Signatures of all the parties. Compensation is not legally required. It would make sense for it to be in an agency agreement. That's the place we talk about it, but it's not legally required to be in there. What you got, Ekta?
Can you repeat that question where you said most 70% of the students get it wrong?
Yeah. Which type of document outlines the relationship between the buyer and their agent, the respective obligations between those two parties, and the type of home a buyer seeks to purchase? And so many students, Ekta, pick listing agreement. Even though it says buyer, buyer, buyer. That's a buyer agency agreement. But the amount of students, I'm telling you, it is astounding to me. They pick listing agreement. Listing agreement would outline the obligations between the seller and their agent, the home they intend to sell, the obligations between those two parties, right? You got to be thinking about the parties for these because it is very specific, and buyer agency agreement and listing agreement are both options on those types of questions. It should be pretty straightforward. It's in the name of the question, but people pick it all the time. Talked about property management agreements recently, agency contracts. Remember too, just as a side note, property management agreements in North Carolina can automatically renew. Buyer agency agreements, listing agreements cannot, but property management agreements can automatically renew. And then remember too, you are typically acting as a general agent on behalf of your client when you're a property manager, because you can do certain things, bind them to certain things like leases and do evictions and, repairs and things of that nature. Working on behalf of buyers and sellers, special agent. Working as a property manager, general agent, and you on behalf of your firm, also general agent. Universal agent is not a power that a real estate broker is going to have. So, we've talked about the different types of commissions. Obviously, there are percentages of sales prices. We can do flat fees. There's that protection period we talked about where you may be entitled to getting paid even after it's terminated if it's that period of time, right? Remember I told you from a state test point of view, sometimes it's tested as the extender clause or the tail clause as well as the protection period. And remember, don't confuse that with the protection agreement, okay? Different things. Also remember net listing. Net listing is not an agreement in and of itself. It's a compensation style. It's where we agree that I'm going to get anything above and beyond what the seller said they needed to make. Is it illegal? No. Do not test it as it's illegal, but it's frowned upon due to the likelihood of impropriety, right? That's what it says. Use of net listing agreements is either illegal or strongly discouraged in most states due to and so it's not illegal in North Carolina, but it is discouraged. What you got, Robert?
Sorry, I tried to raise my hand a second ago, but I failed. I'm like
Backtracking, that's okay.
I wrote something down, and I don't know if I'm just confusing myself or I was tired and I wrote down craziness, but we were just talking about different types of agency, but obviously buyer's agent, buyer, seller's agent, seller. But I wrote down talking about a selling agent that's assisting, and I wrote down that they're representing neither.
They could be representing either. So remember when we talked about this, okay? Listing means you represent the seller, okay? A listing agent represents the seller. A seller's agent represents the seller. Those are synonyms. Listing agent, seller's agent, and so a seller's agent signs a listing agreement, right? A listing agent signs a listing agreement. Buyer's agent represents the buyer, signs a buyer agency agreement. But I told you the word selling, to be a selling agent, selling's a verb. And so to be a selling agent just means you are assisting a buyer. And listing agents assist buyers, seller sub-agents assist buyers, and buyer agents assist buyers. So it never tells you where your loyalties lie when you see the word selling. You need more. So Robert is assisting a buyer customer as a selling agent. Well, that tells you that your loyalties are where?
With the buyer.
No, hold on. Robert is assisting a buyer customer as the selling agent.
Yeah.
So the seller. That word customer means that's not your person. And so if I said Robert is assisting a buyer client as a selling agent, you're also the buyer's agent because I said they're your client. So you need something else. Selling will never tell you where your loyalties are. Selling just means that you're currently assisting a buyer. And I gave you the analogy Best Buy, right? When you walk into Best Buy, they will assist you because they are selling you on stuff at Best Buy, but they don't necessarily work for you. They work for Best Buy. So a selling agent could be a buyer's agent. A selling agent could be a seller's agent or seller sub-agent. Just means you're assisting the buyer. Never tells you your loyalties. You need more if we've given you the word selling.
No, that's perfect. That's exactly what I needed.
Yep.
I actually recorded my notes properly.
Yep.
It's like the ing. I kept reading selling a seller in my brain.
A lot of people do that, which is why I spent so much time like saying selling agent. Selling, yeah.
I need to underline that ing.
Here you go. Yeah, I told you that one was that's a little dangerous on the test. You know, people get tripped up. And it really is about catching this stuff sometimes, right? The word customer, the word client, you know, the word buyer's agent. I mean, you've got to catch this. ABC Realty. Because if you miss these things, you know, missing one thing absolutely changes the outcome of the question. And that's why I told you, you know, when you're reading these test questions, don't go to like your first answer choice. I know that most test taking strategy says, you know, go with your gut, go with your initial answer. I don't necessarily think that's a good strategy for this because there are so many answers that when you're reading the question, like they could seem right. So that's why I told you got to read the question. You got to fully understand what is it asking you and then read all the answer choices and review the question and make sure, is this the best answer? And, you know, just a case in point, you know, I told you when we're talking about the working with real estate agents disclosures, folks, you've got to understand that no, they don't legally have to sign it. That's another thing that eats people alive on the state test that I'm going to be giving you this weekend. People are like, oh, you can't have a buyer agency agreement unless they've signed the working with real estate agent disclosure. Yeah, you can. We can't legally force them to sign a working with real estate agents disclosure. It's just a disclosure. If they tell us to kick rocks, we got to kick rocks, right? We'll make a note that we reviewed it with them. So pick the best answer, right? Can you have a buyer agency agreement if they don't sign it? Yeah. The other thing too, the deadline is for substantial contact. And so I told you, if I give you a test question and I say, you know, you're having a conversation with somebody and they let it slip that they're going through a divorce, don't tell me that you're in breach of your fiduciary duties because you're not a mind reader. The deadline is for substantial contact. So what's the answer going to be? At that point that they state that, stop them, present it, review it with them. That's the deadline. You're not in trouble yet. You're in trouble if you don't give it to them after they have gone there. The second they start talking that confidential stuff, Boop. And you tell them to be quiet, and then you explain it to them. So you're going to pick the best answer. And you know, best answer is going to be, what's the legal requirement? I promise you on the test, the answer is not going to be, give it to everybody the second you meet them. No, because we don't legally have to, right? Could I do that in real world practice? Sure. But is that how I'm going to be testing it to you? No, because I can't test you on best practices. I'm testing you on laws, expectations, obligations, and rules that we've been going over throughout this this course. So just be careful. Fair housing, obviously, we talked about. Be very careful. These terminologies you've got to know, okay? They are interchangeable on the test. So blockbusting, also called panic peddling, inducing somebody to sell by fear of a certain protected class moving into the area. You know, hey, you need to sell now because there's a lot of blanks moving in. It's going to hurt your property values. Whatever that is, okay? That's blockbusting, also called panic peddling. You can just see one or the other on the test, and you got to know they mean the same thing. Now, they're never going to be in the same test question because that would not be fair. But steering, also called channeling, when you like to live in this predominantly Caucasian area, when you like to live in this predominantly African-American area, when you like to live in an area away from kids, when you like, whatever it is, that constitutes steering or channeling. Even at their request, it's still not okay. Of course, obviously, discriminatory advertising is a violation of fair housing. And then the other big thing that's testable is the exemptions. Okay, I told you. From a national point of view, a for sale by owner is exempt from adhering to fair housing, so long as they're not doing multiple homes and flips a year. And then, of course, the roommate rule applies. If you live in one of the units that you're renting a home, a room in, or up to a quadruplex and you live in one of the units, you can pick and choose who lives there as long as it's not based on race or color, because that would still be a violation of the Civil Rights Act of 1866. But you could pick and choose based on religion. You can pick and choose based on sex. You can pick and choose based on country of origin. Like, none of those are going to be illegal or violations. What you got, Jonathan?
Sorry, if you mentioned it and I zoned out, just ignore me. But can we go over the dates? Because those dates trip me up on what went into effect on which date with fair housing.
Yeah, to be honest, you know, as much as I teach this. So, Civil Rights Act 1866. Fair housing is 102 years later is the way I remember it. So 1968. Then we had I want to say it was the Community Development Act of 1974, which added in sex. I'm just going to pull up the image here because I don't want to tell you wrong. Doing this from memory is dangerous. Oh, let's see. Civil Rights Act of 1866. Doesn't have the other dates in here, but I know they do like to test on them sometimes. So let me pull up this textbook. It's like 1974 and...
I have them in front of me.
What is it? Yeah, go ahead.
So 68 was race and color. 74, race, color, religion, and country of origin.
Yep.
74 is sex. And then 1988 is Fair Housing Amendment Act, disability and familial status.
There you go.
And then in 88, it also became legal to screen basis credit and criminal background.
Yep, there you go. So, Civil Rights Act of 1866. Okay, memorize that one. 102 years later, Fair Housing Act of 1968. Race, color, religion, national origin. 1974, Housing and Community Development Act. Sex. Historically, that was male or female. Executive order in 2021 included gender identity and sexual orientation in interpretation somewhat. And then 1988, which was the year before I was born, was the disability and familial status. And then, of course, the ECOA is the same year as the Housing and Community Development Act, 1974. But I don't think they're really testing you on the year for ECOA. Yeah.
Awesome, thank you.
Yeah. What you got, Ekta?
Where does the North Carolina Fair Housing Act fits here? And what are the key terms for that one?
So the North Carolina Fair Housing Act is, I want to... Would you say what was the year?
Was it 83? 1983?
That sounds right. But the North Carolina year, you're not going to be tested on the year for the North Carolina one. So you don't have to worry about that one so much. But yeah, 1983. And remember, the protected classes are all the exact same. The only real testable difference between the North Carolina fair housing and the federal fair housing, the exemptions are a little bit different. In North Carolina, for sale by owners are not exempt from adhering to fair housing. And then remember too, for whatever reason, we state that if you live in the unit or one of your family members lives in the unit, then you are exempt from the roommate rule up to a 4-unit dwelling. And then of course, North Carolina also allows same-sex dormitories. That is legally okay. And then the other big thing that's testable that you have to know, I know for a fact it's on my test, is that the enforcement of the North Carolina fair housing is the North Carolina Human Relations Commission. Now, the Real Estate Commission, Human Relations Commission. And then federal is HUD, Department of Housing and Urban Development. What are we talking about now? Do not call. Remember the do not call. We talked about the solicitation legislation. What you got, Nathan?
And for somebody to report that discriminatory action is 12 months is a year, right?
Yep, year. They have up to a year to report it to HUD on the federal level and or the state because of the statute of limitations on those.
Gotcha.
Mm-hmm.
I'm gonna let you move forward, Seth. But
No, you're fine. Ask the questions.
I just saw at the ADA when I remember there was a question that tripped me up on the practice final. It was about commercial and residential and like what all the American Disability Act applies to. Can you just high level overview real quick?
Yeah, so ADA is Americans with Disabilities Act. And so basically that applies to everywhere people go, but not where they live. So places you work and stores and establishments and things like that. And so, ADA also recognizes service animals. Service animals legally are now a dog trained to perform a certain task on behalf of somebody with a disability. And so service animals can go anywhere that people can go. Service animals are not considered pets. And so this is the reason why you have to have handicapped parking spots and you have to have the wheelchair ramps in parking lots that go up to the curbs, that you have to have handicapped stalls in places that you go, places that you work. Fair housing deals with places you live, which it gets a little confusing because obviously a apartment complex with 700 units is a commercial building, but because they're residential dwelling units, fair housing applies to those because they are individual residential units where, individual families are living. So fair housing has jurisdiction with residential and ADA has it with places you go for public. And then the other thing that comes up sometimes, and I don't think the year is, but I think it was 1991, remember? Basically, any buildings prior to March of 1991 were grandfathered in from having to comply with, fair housing requirements for accessibility for these apartment complexes. But anything built after that also had to have the wheelchair ramps in the parking lots, had to have first floor dwelling units and things of that nature. So, yeah. And then, so remember also too, fair housing does recognize emotional support animals as well as service animals. I don't hope they're not going to go that way on the test because those are complex, but they do recognize that under disability or handicapping condition.
Yeah, that's how they. I think it was you that made the test. That's how you got me.
Yeah, that one. Mm-hmm.
It was like if a residential unit is more than 4 units, and I was like, oh, that's commercial, and I was like, yeah, that's what got me.
That yeah. Yeah, it is a commercial building, but it is a domicile, right? It's where people live, so that's why it's still under fair housing.
Okay.
Yep. Yep. Now, arguably speaking, the leasing office would be subject to ADA because that's where somebody works. So remember, do not call legislation. Remember, deals with phone calls, case solicitation by way of phone calls. The most testable aspect, obviously, if somebody's on the list, you can't call them. This deals with real estate agents and cold calling. The exceptions, though, are the more testable thing. So if you've had a business relationship with somebody in the past 18 months, you can call them. If they've done a direct inquiry on your website within the past 3 months, you can call them. If they give you a direct invitation to call them, you can. You need to keep a record of that invitation. And if you have a personal relationship, right? Your brother, your sister, your aunt, your uncle, your niece, your nephew, something like that. The other thing that they love to test on is, well, what about a for sale by owner? If a for sale by owner is on the list, you can't call them to solicit. If a sale by owner is not on the list, you can call them to solicit. But if a for sale by owner is on the list, you can call them if you have a buyer client interested in their property, but that's not solicitation. So understand that expired listings of other brokerage firms or for sale by owners are not automatically exemptions because you didn't have a relationship with that expired listing. And the for sale by owner, you can only call them if you have a buyer client interested in their property. Of course, the other big solicitation legislation was the CAN-SPAM Act, right? Deals with spam emails, email marketing, has to contain a conspicuous opt-out or unsubscribe notice and the address of the company. That's the requirement for the CAN-SPAM Act. Antitrust laws, careful on those. The big things that were prohibited, price fixing, boycotting, and allocation of markets. Make sure you're aware there are very, very substantial fines up to millions of dollars if you're a corporation or hundreds of thousands of dollars as an individual, jail time. And so even saying things as that's the customary rate, that's the going rate, would get you in trouble because that could constitute price fixing. So the answer is always, that rates are negotiable, commissions are negotiable. Okay. Price fixing, colluding to set prices. Boycotting would be trying to limit or single out a business. So they would go out of business. So just be careful. You could get some different test questions on, this person said it's the going rate, which the following could they be guilty of? Or, this person, set prices with somebody else. What law would this violate? Just be careful between solicitation laws and antitrust laws. We haven't really talked about this except in passing, and so it's on here, so let's just make a mention of this. Obviously, I told you that real estate brokers are one of the most sued careers next to doctors, unfortunately, and so there is something called E&O insurance that we have to maintain as real estate licensees. It's kind of like your malpractice insurance as a doctor, but it's called errors and omission insurance. So if you see that on the test, that is an insurance. We have to have errors and omissions called E&O insurance. So here is the more specific side of brokerage practices, right? We're kind of talking about brokerage relationships and practices from a national point of view. Here's from a state point of view. Obviously, let's see here. What is this? Land use controls. This is not so much brokerage practices, but we did talk about this in another section. Public versus private land use controls. Obviously, the government has the public land use controls. Private or private property owners. Don't pick HOA as enforcement for private land use controls. It's injunction. Civil injunctions is how you would enforce private land use controls because there's not always an HOA. That one's not super important. This one, yeah. Of course, identifying red flags. This is going to be something that you may have a question on. Which of the following is true about a real estate broker's obligations? We need to help our clients decide if this property is going to meet their end use. So if they're trying to build a commercial building and it's zoned residential, we need to discover that because they may need to potentially do what in order to be able to use this property. If it's,
Can you repeat that?
Yeah. If this property is zoned residential and they want to build a commercial building, we need to discover that because if they're interested in this property, they would potentially have to do what to it in order to be able to use it?
Get it rezoned.
Get it rezoned. There you go. Get it rezoned. That's not a variance because we're asking to build a commercial building in a residential area. That's rezoning. Okay, that is way bigger than a variance. A variance is we're going to build the right building, but we're asking to break a rule or two. You got to keep those distinctions prominent in your mind. What you got, Robert?
I know there's a couple questions that had me thinking about that. So I think the answer option was put your client in contact with the county planning commissioner. If they have questions about zoning and rezoning and whatnot. And I can't remember, was that the correct one? Because you're not doing that yourself. You're not in
I think that the question was that a doctor wants to buy a property where he can live and also practice, something like that. Mm-hmm. What would you do, right? That was the question.
And the answer was get him in contact with the local planning commissioner or planning board or something like that?
That was one of the choice, yeah.
Was that the right answer? Because that sounds like a good answer.
Yeah, that's what I answered. Yes.
Yeah, I mean, and here's the reason why. I mean, so when we're talking about these things, and this is where I mean, even as an instructor, folks, I've been teaching this crap forever, and I can't just off the top of my head tell you what the answer is because it depends on the answer choices. There's always a best answer. That sounds like a good answer. Without saying the rest of the choices, I can't tell you if it was the best answer. But that I would go that direction. I mean, obviously, we're not necessarily going to be able to get things rezoned. That's outside of our wheelhouse, and so we need to.
I was just confirming that. Like, obviously, we're not getting it rezoned, but if they're trying to like get into the tidbits and whatnot, like we can't be interpreting any like legal.
There you go. That's always going to be the answer. We cannot interpret legal things. So even if it's like, oh, there's some ambiguity in restrictive covenants, if one of the answer choices is as a broker, you're going to help interpret these. No, you're not. You're going to refer them to consult an attorney if there's any confusions with restrictive covenants. So yeah, that's exactly right. Never put us in the position of overstepping our authority. And Nathan says that was the right answer, which does sound like a good answer.
Sweet. Thank you, Ekta.
No. So, yeah, good questions. Talked about those red flag situations, environmental issues. I'm going to remind you of a couple environmental things just because I've heard that it is on the state licensing exam more than I would anticipate. So two things. Number one, underground storage tanks that have leaked. Remember, one of the big testable things is the person who owns the property may be liable for cleanup even if they're not the ones who installed the tank. The other thing that's very testable is CERCLA, and I can never remember exactly what it stands for. It's a ridiculous name. Also called the Superfund. And remember, if there's like a CERCLA designated toxic site, it's a material fact forever. Okay, if they've identified it as a toxic site, it is a material fact forever. The underground storage tank sometimes can be cleaned up, remediated, and it's no longer considered. But if it's considered a CERCLA toxic site or an environmental contaminated site, it's a material fact forever because these are arguably things that we may not be able to remediate or fix. So just be careful with those. Of course, different laws and rules here. Delivery of instruments rule. We have to deliver everything immediately in no case later than 3 days. And so that would include a lot of different things. So completing the RPODs, obviously part of our obligation is I'm like the serial material facts. I'm like, what is happening here? The CERCLA. I see where you fix it.
It keeps correcting.
Yeah, that's because it's not a word that it recognizes. I would say so. Yeah, the CERCLA material fact also applies to the properties adjacent or near a site. I don't know that the questions are always going to go that specific, but if that's the direct question, would it be a material fact that a contaminated site is nearby? Yes. I would say yes.
I thought I read that last night, but yeah, it's like if your property is near a CERCLA site, that can also be a material fact.
Yep, absolutely. Present all offers immediately in no case later than 3 days. Obviously, we cannot accept or reject offers on behalf of our clients. We are special agents. We don't have the authority to do that. We're going to advise them. The other thing, too, remember when we're dealing with multiple offers, the way that it's always tested is deliver them immediately in no case later than 3 days and in no particular order. We don't care what order they came in. We're not going to deliver them as the best, the second best, the worst. We're not going to deliver them as this is the first that came in, this is the second, this is the third. We don't care. We're going to give you all of them because we legally have to. And then we are going to review them with you and help you pick the best one. There you go. Back to Comprehensive Environmental Response, Compensation, and Liability Act. It's the R that I always mess up because I always want to say it's like reduction, right? Environmental reduction. No, it's response. That's when I always mess up. Record retention. Remember record retention, handling, retaining records for 3 years from the date of last activity. Typically that's closing, but if there's a dispute of earnest monies, it would be whenever we disperse the earnest monies. Of course, we've talked about the different ways we handle trust monies, right? Custodial, ready, available on demand, has to be separate from yours. To mix it with your monies with it would be commingling. To pay bills out of a trust account would be conversion, both highly illegal. This goes into some of the other things that we just recently talked about. Remember, a provisional broker cannot hold on to trust monies. They got to deliver it to their BIC immediately if they're given it. And then, of course, aside from the PB, when you get earnest money checks with an offer, you can hold it until there's offer acceptance and then have to deposit it within 3 days. If it's cash, you have to deposit it within 3 days. You can't hold it even if there's no offer acceptance. And then remember, don't confuse that with the obligations to deliver it to the escrow agent on the contract. So the 2T says it needs to be delivered to the escrow agent within 5 days of the effective date of the contract. What the depositing rules state is they need to deposit it within 3 days of getting it if they're already under contract, or if they could hold on to it if they got it before it was under contract, if it's a check, but not cash. Prohibited practices. These are some of the different laws we've talked about throughout the 93A-6A 1 through 15. Misrepresentation or omissions of material facts. You're going to have to make sure you can differentiate between the misrepresentations and omissions, the negligence and the willfuls. Of course, understand puffing, not illegal, but there is a huge line between puffing and misrepresentation. Best view of the ocean, and it's an okayish view of the ocean, that's puffing. Best view of the ocean, and there's no view of the ocean, or you have to go on the roof like we said, that's misrepresentation. Okay, nobody's going on the roof to get a view of something. And so if it says it's looking at the ocean but it's not, that's a misrepresentation. If it says it's the best view and it's okay, that's puffing. Of course, the facts about the material facts, the categories, facts about the property itself, facts relating directly to the property, facts in regard to the ability of your principal to complete the transaction, and any facts known to be of special or specific importance to a party. The things we said are always material facts in North Carolina. I told you right here. Synthetic stucco, even if it's been replaced, is a material fact for life. Polybutylene pipes that have leaked, even if they've been repaired or replaced. And a meth house. Okay, material facts for life in North Carolina. What you got, Jonathan?
So this is one of the questions that tripped me up. So the facts known to be of specific importance to a party, that was a question, and I have no idea what that means, Seth.
If they tell you, let's go back to that example that Ekta and Robert were just using. I need to operate a home business out of my house. That's now something of specific importance. So we need to help them look up the zoning ordinances and the restrictive covenants so that they can see if they can do that. Or if somebody tells me, well, I have to have a place to park my RV. We need to make sure we look at the restrictive covenants to make sure they can legally park their RV in their yard. Once they've made it known to you that it's important to them, it's now our obligation to help them discover it. If they want to use it as a short-term rental, if they want to rent it out, if they want to not be near a cemetery, as soon as they state that it's important, it's now a material fact that we have to help them discover.
So does that, in the fact that that's now a material fact, does that mean you have to disclose it to the other party?
Well, it's only material to them. So when you're dealing with stuff like this, it's like certain things are material to certain people. So for instance, when we talked about material facts disclosure in clients versus customers, well, if I'm a listing agent and I find out confidential information about a customer, that becomes material to my client, and I've got to disclose that to them. If I've got multiple offers, that's material to my client. I've got to disclose that to them. But if my buyer says, well, I don't want to be anywhere near a cemetery, that only matters to them. And so it's not something that I need to tell anyone else. They're like, well, my buyer's a chicken and they don't like cemeteries, right? So it's one of those specific things. It's only material to them because they've stated it. And do understand, too, that does not supersede the categories that are not material facts. So even if they say, well, I definitely don't want a haunted house. Okay, well, that's not material fact in North Carolina. So unfortunately, we still don't have to, go into that if we don't want to. But yeah.
Okay, that makes sense. Thank you.
Mm-hmm. So things that are stigmatized, aka not material but not desirable, as we said in North Carolina, haunted, death or illness of a previous occupant, criminal activities, sex offenders nearby. Obviously, we can talk about those things, except whether somebody has had or died from AIDS or HIV, because that's protected under fair housing. So we cannot touch that one with a 10-foot pole, but all the other ones we could talk about. Remember, it's not on my test, but I told you on the state licensing exam, you could see the term Megan's Law. Megan's Law is the law in regard to the sex offender database. Okay, it's the one that requires sex offenders to be registered. Of course, some of these other rules or laws, should I say, that'll get us in trouble: discriminatory practices, the unauthorized practice of law, drafting of contracts, Most answers are going to be have an attorney draft the stuff, but can your clients draft their own? Yes. Is it advisable? No. But if the question is it legal? Yes. Is it advisable? No.